Hi, my name is Ishita Dutta, a legal intern at LEXIS and Company, and today I will be talking about the topic Death Certificate of a Missing Person. According to the Registration of Births and Deaths Act 1969, the occurrence of death of a person has to be intimated to the Registrar of Births and Deaths within 21 days of such death. The procedure for registration of the death is well defined in the Act. It is imperative to ensure death registration and obtain a death certificate to avoid any issues relating to life insurance, probate grant or administration letters that may arise later. Nevertheless, the procedure to procure a death certificate for a missing person is complex and time-consuming. So since the process of proving death without a body requires some time and wading through formality, it may be months before one can prove death and obtain a death certificate. So in the case of presumed death, a death certificate cannot be obtained until a declaration to that effect has been made by a civil court. What occurs if there is no body? So an individual is presumed to be alive until they are announced dead. Up to that point, no one has the authority to manage the deceased individual's assets, regardless of whether claimed exclusively or mutually, life insurance, and it may not be possible to replace the individual as a regulator of a trust or an organization. The assets are viably frozen and no one has the authority to manage them. Depending upon the conditions, it can bring about trouble and difficulty for the individual's family, employees and creditors. If the individual had made a power of attorney before they went missing, things could continue as though the individual were alive at that point in certain regards. So how does the application work? To answer this, I would like to say that under Section 108 of the Evidence Act, a person who remains missing and has not been heard of by persons who would have usually heard of him for 7 years is presumed to be dead for all legal purposes. To prove that a person has gone missing, one has to show that the person seeking such a declaration have taken appropriate steps to find the person. This may include filing a missing person complaint with the police, issuing advertisements, or contacting relatives or friends, and somewhat like that. The court requires proof regarding the individual's background, disappearing circumstances, and any witnesses account of disappearing the last persons to see the missing individual alive. The court also requires evidence regarding what has occurred since the disappearance, both in search efforts and whether any action may propose the individual is as yet alive. For example, bank account activity. Once the court is satisfied, it issues a decree declaring the person to be dead. Only after the procurement of such a decree, one can obtain a death certificate which is obtained from the registrar. This assumption does not mean that the process is automatic. To get the advantages of this assumption and have the order made, the applicant should in any case introduce the entirety of the evidence to satisfy the court that the individual has disappeared and no indications of life. It is as yet a complex legal process to go through. So what is the procedure to issue death certificates for a missing person? Given the provisions contained in the Registration and Births and Deaths Act 1969 and the explanations as given by the Government of India, Ministry of Home Affairs, New Delhi, and in the light of way that certain people tend to impersonate themselves as their legal heirs of the person, people with malicious motives, the following rules procedures are issued for the convenience of the general public and the guidance of the civil registration functionaries. First is death certificate for the missing person can be claimed by the legal heirs. In this manner, those claiming the death certificates must deliver the actual evidence to support their legal heir status. Second is under Section 108 of the Indian Evidence Act 1872, a missing individual for over 7 years is assumed dead, notwithstanding that the said section is silent about the death's date and place, which a competent court can decide depending on the oral documentary evidence before the court. So according to the explanations given by the Ministry of Home Affairs, each candidate or legal heir ought to hence get necessary orders from the competent court by swearing in necessary affidavit, not just for getting the date and place of death of the missing person, but additionally for going through the deferred registration process under the Registration of Births and Deaths Act 1969. Specific format is being made accessible in all the RBD centers. So next is all the candidates or legal heir of the missing person will present the affidavit appropriately solemnized before their respective judicial first-class magistrate, as the case might be alongside the death report and any remaining supporting proof or records as accessible with them to help the missing event of the individual concerned. FIR lodged or a published copy of missing people in the Daily Telegrams or any reference from the business department and so forth to the office of the Chief Registrar of Births and Deaths for verification. So what were the court precedents? So in Life Corporation of India versus Anuradha, the Apex Court explicitly stated that neither the Evidence Act nor logic or reason could permit the presumption of death to be stretched to such an extent that the person not heard of for 7 years was dead on the date of his disappearance. And at what point of time was a person not dead is a matter of presumption but of factual or circumstantial evidence. The onus of proving that the death had taken place at any point within the 7 years of disappearance lies on the person who claims it. There is no presumption of the time of death of a person unless a dispute comes before any forum or in any legal proceeding. So the presumption of death cannot be raised. So in the Union of India versus Polymetla Mary Sarojini, it was held that there was an inherent danger in presuming that the date of a death of a missing person shall be the day he went missing. It would lead to the failure of several legal heirs claims due to limitation periods expiry, despite the presumption being raised only after 7 years from the date he was last heard of. Therefore, the court opined that such a person could be presumed to be dead on the day after the completion of 7 years. In Sanju Devi versus State, it was held that a person must file a suit for declaration of civil death to successfully establish the factum of death. Death itself is not a fact per se, but itself in question. It is required that a civil court shall pass a decree declaring the concerned person's death. Only when such a declaration is made can the benefit of the estate or succession rights vest in the legal heirs. So in conclusion, I would like to say that when a family member dies and no proof of passing exists, the individual should be lawfully pronounced expired. This process is known as death in absentia. It is often difficult as it requires the relatives to deal with their misfortune and navigate through a very complex framework. Thank you so much.